Every crisis reveals the same hard truth. The people who thought they were financially secure discover they were holding nothing but promises. Paper contracts, digital balances, stock certificates, all of it can disappear overnight when systemic weaknesses are exposed. But here's what most people don't know, and what the financial industry rarely highlights. There are certain assets that even the most aggressive creditors, the most challenging bankruptcy courts, and the most severe economic downturns cannot touch. These are the fortress walls that protect your future when everything else feels uncertain. The misunderstanding runs deep. We look at our bank statements, our investment portfolios, our real estate holdings, and we think we see wealth. But what we're really seeing is a collection of claims, promises that someone else will honor their obligations to us. And promises, as history shows us again and again, are only good until the day they're not. The mortgage crisis taught millions of homeowners this lesson in painful ways. The dot-com crash showed investors that stock certificates can become virtually worthless. Bank failures from Cyprus to Lebanon reminded depositors that their money in the bank was never actually theirs. It was a loan they made to an institution that was unable to return it. But there's another category of assets entirely. Assets that exist outside the reach of creditors, beyond the grasp of bankruptcy trustees, protected by laws so fundamental that they've survived every financial challenge in American history. These aren't exotic investments or complex financial instruments. They're legal shields built into the system itself, designed to ensure that even when markets shake, certain foundations remain intact. The real issue is that most people don't know these protections exist, so they make decisions based on fear instead of knowledge. Let's start with the fortress that protects more American wealth than any other: retirement accounts. When people hear the word bankruptcy, they imagine losing everything. They picture creditors seizing bank accounts, selling homes, liquidating investments to pay debts. What they don't realize is that certain retirement accounts are completely untouchable, no matter how much debt you carry or how serious your financial setbacks. Under federal law, specifically the Employee Retirement Income Security Act, qualified retirement plans are not considered part of your bankruptcy estate. They don't belong to the bankruptcy court. They can't be seized by creditors. They remain yours, entirely and completely. This isn't a loophole or a technicality that might get closed someday. It's foundational law that recognizes retirement security as essential. A person facing bankruptcy can have millions of dollars in a 401k, and every dollar stays protected. Creditors cannot make claims against it. It exists in a legal sanctuary that has been tested through decades of court challenges and has never been breached, regardless of the circumstances involved. But the protection goes deeper than just the account balance. It extends to the growth of those assets, the dividends they generate, even the loans you can take against them. A 401k that contains $500,000 when you file bankruptcy might grow to $800,000 during the proceedings, and that growth remains just as protected as the original amount. This creates a remarkable situation where someone can emerge from bankruptcy with their long-term financial security completely intact, ready to rebuild from a position of strength rather than starting from zero. The same protection applies to most employer-sponsored retirement plans. 403(b) accounts for non-profit employees, profit-sharing plans, pension benefits, all fall under the same legal umbrella as long as they are qualified under ERISA, which covers the vast majority of workplace retirement plans in America. Even if your employer mismanages the plan or fails to follow proper procedures, recent court decisions have confirmed that the protection remains in place. The Third Circuit Court of Appeals ruled explicitly that ERISA's anti-alienation protections apply regardless of whether the plan operator follows all the rules correctly. Individual retirement accounts operate under different rules, but they still receive substantial protection. Federal bankruptcy law protects traditional and Roth IRAs up to specific dollar limits that adjust for inflation every 3 years. As of the most recent adjustment, that protection extends to over $1 million per person. And here's a crucial detail most people miss. Money rolled over from a qualified employer plan to an IRA retains the unlimited protection of the original plan. So that 401k money doesn't become more vulnerable when you change jobs and roll it to an IRA. It carries its fortress-level protection with it. This creates a strategic foundation that most Americans never fully utilize. While they worry about diversifying their investments or finding the perfect asset allocation, they're missing the more fundamental question. How much of their wealth exists inside these legal sanctuaries versus how much sits exposed to the financial risks that periodically emerge? The implications of this protection are staggering when you consider how most people allocate their resources. They max out their 401k contribution to get the company match, then pile everything else into taxable accounts, real estate, or business investments. But those additional assets sit completely exposed. The business can fail, the real estate can be foreclosed, the taxable investments can be seized. Meanwhile, they could have been contributing to additional retirement vehicles that would have remained fully protected. Consider the difference between two business owners facing the same crisis. Both have built companies worth millions. Both face lawsuits that could threaten them financially. The first owner kept most of his wealth tied up in the business and real estate. When the judgment comes, creditors can seize the business assets, force the sale of properties, and leave him with almost nothing. The second owner systematically moved wealth into protected retirement accounts over the years. When his business struggles, he loses the company but emerges with his retirement savings completely intact, potentially millions of dollars that creditors cannot touch. But retirement accounts are only the beginning of the fortress. Your primary residence receives protection through homestead exemptions, though the strength of that protection depends entirely on where you live. Federal bankruptcy law provides a baseline homestead exemption, but states can offer much stronger protection. In Florida, there is no limit whatsoever on homestead protection. A primary residence worth $10 million receives the same complete protection as one worth $100,000, as long as you meet the residency requirements. This creates a remarkable arbitrage opportunity that few people understand. While most investors chase returns in volatile markets, some recognize that moving to the right state can provide asset protection worth more than any investment return. The difference between owning a valuable home in a state with weak homestead protection versus one with unlimited protection could mean the difference between keeping your shelter during a crisis or losing it to creditors. Texas offers similarly unlimited homestead protection, along with additional exemptions for personal property that most states don't provide. These aren't recent laws or temporary measures. They're protections built into state constitutions, tested through decades of financial events, and consistently upheld by courts. The protection is so comprehensive that wealthy individuals regularly relocate to these states specifically to shield their primary residences from potential creditors. Social Security benefits represent another category of absolutely protected assets. These payments cannot be garnished, seized, or included in bankruptcy proceedings under almost any circumstances. The Social Security Act creates what amounts to a financial sanctuary that has survived every challenge thrown at it. Even if you owe significant amounts in taxes, child support, or student loans, Social Security benefits remain largely untouchable. But here's where most people make a critical error. They assume protection means they can be careless about how they handle these benefits. Social Security protection remains absolute only as long as the funds stay identifiable. Mix Social Security payments with other income in the same bank account, and you've potentially compromised the protection. The funds become commingled, making it difficult for courts to distinguish protected money from vulnerable assets. The smart approach requires maintaining separate accounts and clear documentation, showing which funds came from protected sources. This isn't paranoia. It's recognizing that protection laws work only when you follow their requirements precisely. Veterans' benefits, unemployment benefits, and disability payments operate under similar protection schemes, but all require proper handling to maintain their sanctuary status. What emerges from understanding these protections is a completely different approach to financial planning. Instead of focusing solely on accumulation and growth, the priority becomes building wealth inside these legal fortresses while minimizing exposure outside them. This doesn't mean avoiding all risk or refusing to invest in opportunities. It means recognizing that true financial security comes not from having the most money, but from having money that cannot be taken away when the challenges come. The conventional wisdom tells people to diversify across asset classes, stocks, bonds, real estate, commodities. But there's a more fundamental diversification that matters more: protected versus unprotected assets. You can lose your business, your investments, even your home in some states, but you cannot lose your properly structured retirement accounts or your social security benefits. They exist in a parallel financial universe where creditors cannot follow. This isn't just about protecting money. It's about protecting your future when the unexpected strikes. Traditional advice often suggests that financial security comes from accumulating wealth in accounts that remain vulnerable. But the real security lies in understanding that certain assets exist beyond that reach entirely. Most people spend their lives building sandcastles, unaware that there are fortresses available. They pour everything into vulnerable accounts while leaving the sanctuaries empty. They chase returns while ignoring protection. They optimize for growth while their wealth sits completely exposed to the next financial disruption. The choice is yours. You can keep playing by rules that leave your wealth vulnerable when trouble hits, or you can start building inside the legal fortresses that have protected Americans through every financial event in history. Your retirement accounts, your homestead, your protected benefits. These aren't just investments. They're the foundation of a financial structure that creditors cannot demolish. The next downturn is inevitable. The question isn't whether challenges will hit your wealth. The question is whether your wealth will be standing when those challenges pass. Now you know where to build the walls they cannot breach. If this changed how you think about protecting wealth, hit subscribe. This content is for educational purposes only and does not constitute financial advice.